Is 1 p.m., so we are going to get started. Good afternoon, everyone. Thanks for joining us. I just want to make sure also that closed captioning is enabled. So let me check. So I have made sure that captions are enabled. If you see CC on the bottom, you should be able to turn them on. If you're having any issues, let me know. And again, thank you for coming. So welcome to part 2 of our guardianship series. This is on guardianship, innovation, and reform. And today you're going to learn about innovative tools and programs from around the country. And you're also going to hear from New York's new director and special counsel of the Office of Guardianship Matters and Elder Justice. I want to mention that this program is supported by the Administration for Community Living, ACL, through their Elder Justice Innovation Grant. And thank you to UCS's Office for Justice Initiatives for putting your faith in my organization, Project Guardianship, as a subgrantee. It's been really wonderful to work on the many projects that we've worked on, including this series. I'm Dina Schwartz. I'm the Director of Guardianship Initiatives at Project Guardianship, and I'll be your moderator today. I just said the word guardianship many times. All right, before we get started, I do need to get into some CLE logistics for those attorneys here who are seeking CLE credit. Please have a writing utensil ready during the program. There will be a code or multiple codes, and they will be announced. I'm going to stop the share for a moment so you can see us. They will be announced at random times. I'm going to say them a few times in a row, but I will not be able to repeat them after. I cannot put them in the chat. Please do not type them in the chat. That might put everyone else's CLE eligibility at risk. If you are seeking credit, an affirmation and evaluation was sent to you before this program started. I will send them again after the program. If you signed up with your personal email address through Zoom, you should get these forms. If you don't, you can reach out to me directly. I'm going to put my email address in the chat right now. But a reminder that I am not administering these CLE credits. There is an email address on the bottom of the form where you send the forms to. They're being administered by the court system. So if you have questions about the actual CLE credits, please make sure that you're addressing that email address. And they ask that you submit those forms in by the end of the day tomorrow. I think that I am through with all the housekeeping. A reminder that your microphones have been muted and the cameras are turned off, but there is chat that is enabled. If you have questions, to make sure that we are able to see it, you may want to enter it into the official Q&A section, but you're also welcome to put them in the chat as well. All right, so I think we can get going. I'm going to do a very quick introduction of everyone. So when I say your name, give a wave, and then I will give a more robust introduction before everyone speaks. So we have Dr. Heather Connors. She's Executive Director at the Center for Guardianship Excellence in Massachusetts. And then we have Wynn Gerhard, who's a guardianship policy and practice attorney at the Guardian Community Trust, also in Massachusetts. We have Nisa Subasinghe. She's the Domestic and Guardianship Program Manager with the Juvenile and Family Services at the Maryland Judiciary's Administrative Office of the Court. So we all got long titles here. And then we have Diana Colon, who's the Director and Special Counsel of the Office of Guardianship Matters and Elder Justice within the Office for Justice Initiatives in the New York State Unified Court System. Thank you so much, everyone. As I already mentioned, I'm Dina Schwartz at Project Guardianship. I work on projects to improve access to good guardianship and alternatives and reforming systems and also educating the public, which is why we're all here. This also includes our nearly 2-year-old guardianship prevention and support helpline. I'll put info about that in the chat. If you have specific questions related to guardianship and its alternatives, we're not talking about those in specifics or able to answer questions about specific cases or anything like that today, but you are welcome to reach out to our helpline. And before we go into our speakers, one more thing, just want to tell you a little bit about our CLE materials. So you're going to have some of the tools and websites and laws that will be mentioned by our speakers. There's also a link to the new-ish New York State Court Guardianship website that was created as part of the same grant that put on this webinar. It has so much information in plain language on Article 81 guardianship in New York and resources for caregivers. The CLE materials also links to New York State's guardianship law. I also want to draw your attention to some national resources, which we are not going to be talking about specifically during this program, but the ABA Commission on Law and Aging has excellent charts that compare specific areas of guardianship law around the country, including monitoring, handling emergencies, definitions of capacity. If you're considering change within your own system, it's always very helpful to see what other states have done, what the laws are in other states. You'll also find legislative summaries from 2020 and 2021 from the ABA Commission on Law and Aging again. This shows legislative change from around the country. It's really another great resource to see what states are doing. The ABA helps put together a legislative update annually for the National Guardianship Association Conference. If you happen to go to that, you can get access to more updated ones, but these are the ones that are available currently to the public. And it could give you an idea of who to reach out to learn about some other successful advocacy efforts other than the one that we're going to learn about today. And then finally, the last national item on there is the 4th National Guardianship Summit put out recommendations for reform and improvement related to autonomy and accountability. You can see some of these recommendations reflected in legislative change around the country. And it's something that also could be helpful to back up any efforts that any of y'all have. All right, so let's get this going. I've talked long enough. We are going to start with our duo from Massachusetts. So let me give you a more robust introduction to the two of them. So again, we have Dr. Heather Connors. She's a gerontologist and advocate for ethical guardianship. And over the past 20 years, she's worked as a professional guardian, researcher, college professor, speaker, and her vision for educating and supporting professional and family guardians has really come to life at this center, which you're going to learn about today. She uses research to develop training programs and tools for guardians and families of adults in need of decisional support. She's a frequent speaker nationally and internationally on subjects related to providing logical, thorough, thoughtful, and well-documented decisional support for adults. We are very lucky to have Heather here with us. And we also have Wynn Gerhardt, who is the guardianship policy and practice attorney. She has nearly 5 decades of elder legal service experience with legal service organizations throughout Massachusetts and New York. She is a founding member of the Massachusetts Advocates for Nursing Home Reform, as well as a member of the Dignity Alliance of Massachusetts. I'm going to name a couple of them. The Massachusetts Guardianship Policy Institute, and just many other places. Read her bio. Those are also in your materials. She has won awards that include Outstanding Elder Advocate of the Year from the Boston Elderly Commission and the induction in the National Long-Term Care Ombudsman Elder Rights Hall of Fame, which I think is very cool that exists. These two women have very impressive bios, and that's just a little kernel of them. So I'm going to stop talking now, reshare my screen, and turn it over to the two of them.
Thank you. So I am really excited. I know that we have a short PowerPoint here and an opportunity for us to talk about some of the really fun things that are going on in Massachusetts. And I will start with the Center for Guardianship Excellence. We are a research and training organization that focuses on guardianship, which is really unique. And we decided to start, we had been looking to make a case for public guardianship in Massachusetts. And that's where the research component came in. And so we recognized that although there was research on so many different areas out there, there weren't all that many researchers focusing specifically on guardianship. So that's when I was hired by our parent organization, Guardian Community Trust, to do research on the need for public guardianship. As I was working with them, I started to recognize that there were a lot of guardians that were being appointed with very little background. And in Massachusetts, there isn't a requirement for guardianship training in order to become a guardian. So I would be in court and I would see the judge say to somebody, well, thank you for being your aunt's guardian. I really appreciate the work that you're going to do. Good luck. And hand the person a decree in order of guardianship and send them off on their merry way. And it was like, oh my gosh, what am I supposed to do? And so that's when we started doing some in-person training. It was maybe 2018, 2019, to speak to guardians in Massachusetts about what was expected of them. That sort of blossomed and turned into the the Center for Guardianship Excellence in 2020. And we went, as many people did, virtual. And that allowed us to go national as well. So it was a really great opportunity for us to expand our reach and really start offering guardianship training across the country. At this point, we offer CEUs, continuing education units, for CGC, Center for Guardianship Certification guardians. So people who have a national guardianship training, as well as national master guardian designations. And we're able to offer CGC CEUs for those people. We've also started offering NASW CEUs and case manager CEUs to people throughout the country. We do a lot of different trainings. So we have a couple of different areas. First, we do online discussions, and that's going to include things like support group. So we do support groups certainly for professional guardians, but a lot of family guardians too. And so we recognize that there are so many family guardians who don't have a network of other guardians to reach out to and have nobody to ask questions to. It's really kind of isolating for a lot of these people. So give them the opportunity to online learn with other guardians, ask each other questions. We at the center don't give legal advice. But there's an opportunity for you to speak to other guardians who may be experiencing something similar to what you're experiencing, or have some of the same questions, or somebody who's gone through something that you're going through now. So it's a great opportunity to develop relationships with other guardians and for us to facilitate that at the center. We have networking groups, and that's a little bit different. It's generally for professional guardians, but it's an opportunity for us to offer a little bit of content, but then offer an opportunity for guardians to contribute their own experiences. So for example, we have just recently started we are working on a interview project of guardians in our research department. And we're speaking to guardians about what they wish they had known before they started becoming guardians. And we learned that a lot of guardians said, I had no idea what to expect in court. So we decided to do a networking event and an opportunity for guardians to talk about what they wish they had known before going to court for the first time and give tips and tricks for other guardians so that they know what to expect. So these networking groups are an opportunity for us to offer a little bit of content, but also offer an opportunity to hear from other guardians so that they can contribute to each other's learning. We also do case presentations, which we call rounds. And you may have heard of rounds from sort of the hospital setting, but this is an opportunity for one guardian throughout the nation, so it's all virtual, to offer a case presentation, talk about a challenging case that they're experiencing, and then give opportunities for other guardians to ask questions, give suggestions, give advice. People may now be exposed to other situations that they hadn't thought about before. So it's a great opportunity for especially guardians who may be private practitioners or in really small agencies to hear cases from other guardians, get ideas about how to proceed in really challenging situations. And, it certainly isn't an ethics forum per se, but it's an opportunity for a lot of guardians to maybe weigh in on a case that you might be struggling with. So we always offer the opportunity for our members to join in. Do you have a case that you're interested in presenting? Please reach out to us. And then when we have support group and networking group and some things, I may say, oh, this guardian spoke about a case that really sounds interesting, and I might invite them to present at rounds. So if any of you are on the call and you have a case that you think would be a really interesting one that we could all learn from, that would be a great opportunity for you to present. We also offer downloadable tools. So many of our trainings result in some sort of a tool that is offered to our members. We put it up on our website for people to be able to download. Sometimes it's something that you want to put up on your bulletin board. Sometimes it's something you want to hand to a client, but it's something really tactical that you can hand out and kind of a leave behind for you to help somebody else's learning. We offer on-demand training. So everything that we offer live, we also record so people are able to come back to it at their own time and their own pace. And that gives really people an opportunity. We see a lot of weekend learning. We see a lot of nighttime learning. So it helps people do things at their own time. And then we offer customized training if people have needs in their own state. Next slide, please. This is just a quick view of what our Learning Hub looks like. And you'll see a number of different categories of learning that we offer. We have more than 50 recorded training opportunities on our website, lots of downloadable job aids. We have a basics curriculum, which is generally related to Massachusetts, but everything else is really for a national audience. Next slide, please. And this is just a quick overview of some of the training that we offer. So if you see anything on there that you think would be helpful for you or your team, I would encourage you to come to our website, and that is in your materials, and sign up to be a member. There is no cost for any of our live training. Our recorded training is $40 per CEU, and we only charge if you're looking for CEUs. If you're just looking for your own professional development, all of that is free. So we have the opportunity to offer an awful lot of training for a very low or no cost opportunity, so that we can really reach as many guardians as possible, because that is our goal, is to professionalize guardians and give them as many opportunities as possible to reach out with other guardians, have interactions with other guardians, and improve their professional development skills. And I think that is the end of my presentation. I'm going to turn this back over to Wynn. Oh, I'm sorry, that is, this is just an example of some of the downloadables that I had mentioned before. So Wynn, take it away.
Thanks, Heather. And it's really great to work with Heather. I also want to just mention as an aside that in addition to all of Heather's great work at the Center for Excellence, and then our educational work and research work, we also actually run a pilot public guardian services project for 3 counties in Massachusetts, serving 80 clients. So we have direct service experience as well. So I'm going to talk about a problem that I think we're all aware of and dealing with, and that's why we're here, and give you our experience in Massachusetts, which is the lack of guardians of all sorts, including professional guardians who can be available to make medical decisions on behalf of indigent and isolated persons. The lack of guardianship is detrimental, of course, to the person who may need guardianship, to access preventive care, to have stabilization in their life, also detrimental to hospitals who have people in the hospital who are ready to be discharged but have no one to give informed consent, and are in some cases getting sicker being in the hospital, don't have access to rehab care, and are taking up the bed in the hospital, which is the hospital's primary concern because it's costing them money. It also costs the state money in terms of medically unnecessary days. In Massachusetts, we actually have, we don't have a statewide public guardian program like many other states do. So we have a 2-tier system, and that's a lot of what has generated the work that our institute does. We have a 2-tier system in that people who have resources and can basically pay for the services of a guardian can always get a guardian. They have to go to court, of course, but they can get a guardian. But if you don't have resources, if you're indigent and you don't have anybody to help in your family or any other resources, it's very difficult to get a guardian. Our hospital association is now showing that the lack of a guardian is the #2 reason for people for delayed discharge from a hospital. Last year it was the #3 reason. It's now risen to the #2 reason, behind the lack of staffing at nursing homes and other post-acute facilities and prior authorizations. Those are the #1 reasons, but we are the #2 reason for lack of guardians is the reason that is keeping people in hospitals. And we all know that the populations that are potentially in need of guardianship, such as the aging and disabled populations, are populations that are growing. There's a high demand for guardianship in a variety of settings. And it's creating a crisis here in Massachusetts, and I'm sure elsewhere, in hospital capacity because of the inability to discharge people who are ready to be discharged but have no one to give informed consent. Our hospital association estimates that about 1,000 people a day are stuck in hospitals, and that the range of time that they're stuck in hospitals ranges from 12 days to nearly a month. And there are even cases where we know it's taken longer. The Boston Globe had an article last year about a young man who was stuck in a hospital for a year. And the reason was that the discharge planners and others could just not locate a guardian. And the hospitals, of course, are concerned, and the state is concerned about the expenses spent on, including this example, 18 million in 2017 for unnecessary medical days in a hospital. In Massachusetts, we did have a case decided by our Supreme Court in 1999 that ruled that expenses incurred by a guardian are necessary to give medical or remedial care, to give informed consent for that care, and also they're necessary as medical expenses. In other words, guardians are essentially necessary for the provision of medical care. So these people who are stuck in hospitals, and also people in the community who cannot get a guardian, do end up suffering. They can become sicker in the hospital if they're in the community. They may become homeless. They may become incarcerated. Their mental and physical health certainly suffers, and they don't get access to preventive care. And guardians can basically help in all of those areas by stabilizing people, by advocating for them, by getting access to medical and social services, and improving their lives, but also saving money for the Medicaid programs, and for many others. Our probate and family court handles more than 20,000 guardianship cases a year, and many times they have no one to appoint as a guardian. And through some of the research that Heather was involved in, we estimate that there are at least 33,000 additional cases of unbefriended people in need of guardians. So these are all the problems, and I know that many of you have these same problems in your work. So I wanted to talk a little bit about potential solutions. So next slide, please. Just to start off with, generally speaking, the solutions involve many things that I know other states are doing, including in New York, which include research about the need for guardianship and the benefits of guardianship, education about that, certainly looking for funding in any way you can, collaborating with other like-minded stakeholders or stakeholders that have common interests, determining the need and the costs and the benefits, and using all of this to educate about the need for guardianship. And I know Massachusetts, I know New York has developed a statewide coalition of groups around the state that are doing public guardianship and looking for more money from the state. We've been doing that as well as in Massachusetts. And that kind of illustrates what I'm talking about in terms of coalitions with like-minded stakeholders, of which there are many. Hospitals actually, and these are stakeholders who might also generate funding, which is important. Stakeholders, including the hospitals, as I mentioned, who have an interest in both discharging the patients and freeing up beds, benefit from public guardian programs, of course. I mean, they're able to go to court, get a guardian, get somebody named as a guardian who can then make the decisions and discharge the patient, and free up the bed. Similarly, somewhat to the same extent, nursing homes benefit. And I know in Tennessee, the hospitals actually contribute to the costs of guardians. So that's one idea. Certainly partnering with other elder and disability rights groups, protective services, state guardianship associations, and elder law attorneys are other potential stakeholders to work with. And then working to determine the unmet need for guardians, and the costs and benefits are certainly an issue. And I know that New York did a wonderful study, that Project Guardianship New York did a wonderful study. That's a great example. Pennsylvania and Colorado also use those types of studies and reports to generate more funding. So this is an example of what we were able to do in Massachusetts, what's up on the screen here, which has really advanced our ability, again, working with the state, to do this kind of study and report. This was a law that was passed last year in Massachusetts, requiring our State Department of Public Health to study and report on public guardian costs and benefits. And you can just kind of see all the issues that are going to be very helpful to get more information. We've actually met with our DPH, this particular work group that's working on Section 30 here, to educate them about what we've done, and about, for instance, Heather's research and the projects that we're doing. But this will go a long way to helping groups, and certainly the state and the legislature, to get a handle on the need and the costs and benefits. So you can see that they are just mandated to study and report on the need and feasibility of qualified professional guardians to give medical consent for indigent persons, and whether that would reduce hospital discharge issues and increase access to preventive care. And then it lists the things that will be very specifically helpful to know, the need for qualified professional guardians, the extent of that need, to help them access appropriate medical care, including preventive care. Data on, this is a type of court guardianship, Rogers guardians, that we've need to know the data on the types of guardianships and the need for them. Fiscal impact on Mass Health, which is our Medicaid program, the fiscal impact of paying for guardians, consideration of the benefits both to the individuals and to the state for creating a method of deducting income from a Medicaid member's income to pay for guardianship, and then other recommendations, and including funding recommendations. And then they are to report to our legislature by the end of July this year, including proposed legislation necessary to carry out recommendations. So the legislature created this, they've mandated this study. It will really be helpful. We've been trying to get this information. We have not been able to access the data from state agencies ourselves, so the DPH should be able to do that. But then in terms of funding ideas, otherwise, I just wanted to throw out some examples. I mentioned, looking to hospitals and nursing homes potentially, and I'm sure many of you are doing this kind of thing, also looking to government agencies. That states are different. I know in New York you have county government, and then there are state agencies that serve the same populations that need guardianship. So that would include in Massachusetts agencies like our Department of Developmental Services, Department of Mental Health, our Elder Services State Agency, the Protective Services programs, and of course the courts. A couple of other potential examples of funding are the Older Americans Act, which is administered by the area agencies on aging, and in each area of the country. We were able last year to get a 2-year grant from our local AAA under the Older Americans Act. It was they sent out an RFP, and we were able to get funding for our public guardianship program to provide guardians. Other potential partners or potential funding partners could be nonprofits, including the ARCs, the National Association for the Mentally Ill, groups like that. The federal funding has been mentioned through the Administration for Community Living, which provided the Elder Justice Innovation Grants, which I know both New York, Massachusetts, and Maryland have gotten to improve the court process for guardianship by getting accurate data, providing training and support for guardians, and making the guardianship process fairer and more efficient. And then another idea is to demonstrate good guardianship with a pilot program, which we're doing in Massachusetts. And I know New York had a pilot project as well. Colorado started with a pilot project and then was able to get statewide funding. So these are ideas about how to seek funding. Another, of course, idea is to minimize the need for guardian by screening populations that might not need guardianship and might benefit by least restrictive alternatives like supported decision-making and healthcare proxies. And I know your Project Guardian in New York is doing that. So those are some ideas about where we might get funding, which of course is one of the essential ingredients for providing good guardianship. So thanks.
Thank you so much, Wynn and Heather. I'm going to stop this share for a moment. I wanted to, first of all, so great to be able to get the legislature to say that some sort of report like this has to be done, because I think that for those who are listening to what's going on in other states and our own state as well, part of the issue with getting things moving in guardianship reform is that there's just never really been that much information about the issues and the need, and like you really need data in order to get funding to do the thing. And so it's impressive to be able to get that done. So I know you worked really hard on that. So congratulations. And I wanted to address we had gotten a question in the chat just to the panelists, but it would be helpful for everyone to know. In New York State, we have 2 different types of adult guardianship. We have Article 17A guardianship, which is for people with intellectual and developmental disabilities. That's diagnosis driven, and the guardian's given all powers. But then we also have Article 81 guardianship, which is it's called guardianship for incapacitated adults, but this has to do with someone's functional capacity, and the guardian can be given limited powers just to what the guardian needs to do, and the person retains every other decisional capacity. The reason I'm bringing this up is because a lot of times resources in New York State may differ for folks who are either one type of guardian or under a certain type of guardianship. But the programming that Heather was talking about it's about guardianship issues in general and learning how to be a good guardian and troubleshooting the issues in general. So I just wanted to throw that out there for some people who feel like they don't have enough resources for them. This is any kind of adult guardian. Is that right, Heather?
It is, and we really focus on best practices. We try to follow as much as possible the standards of practice from the National Guardianship Association and really show people how to take those into everyday life and what that looks like when in practice. So we're not specific to any code, any specific state law. We really try to be able to support people across the country in whatever type of guardianship they're doing.
Great, thank you, Heather. And before we move on to Nisa, I have your first code if you're looking for CLE credits. I'm going to say it a few times. Please write it down. I cannot put it in the chat. I cannot send it to you in an email later. I do not make the rules. So here we go. The code is, now I've lost the code, J628. That's the letter J as in jar, jam, jelly. J628. J628. Okay. I hope that you have written that down because I can't say it again. Okay, so I am now going to introduce you to Nisa. Nisa, again, is the Domestic and Guardianship Program Manager with Juvenile and Family Services at the Maryland Judiciary's Administrative Office of the Courts. And she provides training and technical assistance to judges, magistrates, court staff, and others who handle domestic guardianship and related matters. She has led staff responsibility for Maryland Judiciary's guardianship reform efforts and serves at the state's WINGS. We all know WINGS, the Working Interdisciplinary Network of Guardianship Stakeholders Coordinator. There are many WINGS groups in different states, and they have people from different areas working on guardianship related issues. So she serves as the state coordinator, which is very cool. And she also serves on so many work groups and committees. So please go check out her bio if you're interested, but it's related to forms, model rules, decision making. And prior to this, Nisa served as a crime victim advocate, which I've worked with Nisa before and I didn't know that. So fun fact, and I love that you come from that background. So I am going to turn it over to Nisa now to talk about a really excellent tool.
Thank you so much, Dina, and thank you all for allowing me to be here today. It is such an honor. I love talking about guardianship. I also want to thank Wynn and Heather. You actually teed up my presentation beautifully. So like Massachusetts and New York, we got one of those elder justice innovation grants, and we opted to focus on what's called the healthcare to guardianship pipeline. And what I mean by that is the use of guardianship by hospitals, skilled nursing facilities, and other healthcare settings. Often, the need for those petitioners is narrow. And if Dina, do you mind going to the next slide? Because Wynn broke this up really well. Sometimes it's the need to get informed consent for someone who may be experiencing diminished capacity, or it's tied to discharge planning where there might be a need for somebody to consent to the discharge and related to that, pull financial information about the patient or to pay bills and information about their financial assets, or somebody to get a Medicaid application started may be a condition of admission to another level of care. So until that is all worked out, the patient stays in limbo. And as Wynn noticed, it's a challenge for healthcare settings. It is incredibly detrimental to the patient. And for context, Maryland has been grappling with this pipeline for a number of years. There's been a lot of movement initiated primarily by our hospital association and our healthcare lobby for a faster or a modified guardianship process for discharge purposes or unique to folks in healthcare settings. And we do have a public guardianship program. We've had one for a number of years, and yet we're still seeing these pipeline issues come up. And, it's been a struggle in the time that I've been at the judiciary to really understand the issue. And like folks have said, data is a big part of it. But we also just didn't have the time or the resources to thoroughly study this issue. And one thing that was very helpful is, across the stakeholders, that includes the courts, the healthcare settings, advocacy organizations, public agencies, the private bar, everyone agrees that somebody being in a hospital longer than medically necessary is not working, is not good for the individual. Everyone agrees that the system that we have, which is this reliance on guardianship, in more cases than there probably needs to be, this reliance is not good, which ended up creating some opportunities for us. I mean, where there isn't agreement is whether guardianship is the right answer to these problems. And so, instead of kind of opposing legislation or arguing with each other, we thought, let's use this ACL grant to further study the pipeline. Dina, can we jump to the next slide? And we asked for help from some friends. We used our grant again to focus on this pipeline. We really wanted to understand it and identify ways we can reduce the number of unnecessary or overly broad guardianships in Maryland. We pulled in the ABA Commission on Law and Aging, the National Center for State Courts, and our state protection and advocacy organization, Disability Rights Maryland. For us, they are, they're the folks on the ground, and they are folks who are our subject matter experts on alternatives to guardianship. Because in over the years, folks who are opposed to using guardianship for discharge purposes or for health purposes, really focus on alternatives to guardianship, but we just say that, but aren't really using that in practice. So we thought we'd pull in our experts. And the way we went about this was we talked to everybody. We wanted to learn what are driving these guardianships. What are the issues that haven't come up? So I was serious. We talked to everybody. We talked to hospital administrators, attorneys, discharge planners, social workers, clinicians. We talked to the same folks on the skilled nursing facility side. We talked to advocates for older adults and people with disabilities, legal service providers, the private bar. We also talked to judges and court staff. We talked to researchers. We wanted to get a sense of how everybody viewed this issue and what tools are available. And we learned a lot. And one of the things that we identified as kind of one of the key underlying issues is the lack of education, lack of understanding about what guardianship is and isn't, but also alternatives to guardianship. And, for years, we've kind of been talking at each other instead of to each other. And that's in part because we're all using a different vocabulary. So there are a number of drivers of this pipeline and opportunities to divert people away from that pipeline. But it's hard to do that work unless we're talking to each other. So we took what we learned from this assessment of the pipeline and our state guardianship system generally, and came up with a way to kind of get everybody on the same page. And that's kind of key in addressing the pipeline. And Dina, you can actually skip over this slide and go to the next one. Thank you. So what we came up with is what we're calling the ideal approach. And this is a framework for folks, anybody. I mean, we think this works for as different audiences for how to talk about guardianship and how to identify alternatives to guardianship. The goal of this framework is to avoid unnecessary or overly broad guardianships. Because what we were seeing and hearing from folks is, you have a patient who may be experiencing diminished capacity. There isn't some legwork to determine whether guardianship is needed for a variety of reasons. Kind of guardianship is the first step, even though by law it is supposed to be the last resort. So Dina is kindly going to send you a handbook based on the ideal approach. You can jump to the next slide, please. That we created for healthcare settings in Maryland. And yes, it is Maryland specific, but there are some resources that I think apply in any jurisdiction. But we felt that we needed to do right by our healthcare settings because they are, they asked for it, and we felt like we can create a targeted resource. So this guide includes a tool, the IDEA tool, which I will walk you through in a moment, and resources, including a guide on working with people with disabilities, on alternatives to guardianship that are specific to Maryland and healthcare settings. There are resources about local agencies and advocacy groups that can offer folks support, and this tool, which I'm going to walk you through in just a moment. So the reason we came up with the ideal approach, like I said, we just needed to get everybody on the same page, and also needed to deal with some misconceptions about what guardianship is. I think all of us, we don't have enough resources to do our work, and we are often only able to deal with the issue or the person in front of us, not necessarily appreciating what happens after the fact. So I think folks were treating guardianship as, addressing a person's immediate need. So for example, to get them out of the hospital without really appreciating what happens after that fact, what happens with that guardianship. So we start in presenting the ideal approach, just explaining what it is. And I'm not going to read you this Claude Pepper quote. You're going to get this in the materials. I like to remind myself of this every so often, because while guardianship is a tool in the toolbox and certainly may be appropriate for some of these patients, it is the sledgehammer. And where all that's needed is a Medicaid application or consent to be transferred to a facility. The long-term effects of that guardianship is key. And I'll tell you, our courts, we found, even when there is that limited need, we're seeing plenary or full guardianships rather than more tailored approaches. So that was another issue that we wanted to highlight for folks. Really, what are we talking about and what does it mean long term? Next slide, please. So IDEAL is an acronym. Like I said, it's a framework for identifying alternatives to guardianship, but where guardianship is needed, it's also a framework for, helping prepare that case. And in the resource guide, you'll see a tool built around these 4 steps. So IDEAL stands for identify, evaluate, assess, and limit. Next slide, please. So our first step in the process is to identify what the person actually needs. So we offer here some categories because we can't really talk about what alternatives or to guardianship might be available until we figure out what a person's needs are. And they may just have one discrete need or multiple ones. So we offer here a breakdown of what somebody might need support with. So that's our first step. That's the ID, the identify. And once you identify the person's needs, the next step is to evaluate their capabilities and resources. When we're talking about guardianship, we're talking about whether somebody has decision-making capacity. And one of the things that we heard over and over again is, well, this person has a disability and that diagnosis alone, surely that's enough to prove someone needs a guardian. In our state, that isn't enough. We have to show that the person lacks decision-making capacity. And often when we talk about decision-making capacity in this concept, we focus on what the person cannot do as opposed to what they can do. And there are different legal standards for decision making. The capacity required to execute a contract is very different than the capacity to make decisions about where you'll live or what you're having for dinner. So sometimes that separation of what a person can and can't do gets lost when you just take away all of their decision-making abilities. So really focusing in on what can they do and what decisions are involved or that need to be made when addressing their needs or when considering their needs or exploring options. Um, in evaluating capabilities and how somebody makes decisions or what kind of decisions they make, we also want to make sure that they have the tools available to make decisions. So I can go to the next slide. I'm pretty sure everyone here is in some capacity subject to the Americans with Disabilities Act or Section 504, the Rehabilitation Act. We all have obligations to ensure that people with disabilities receive accommodations. When we're talking about decision-making capacity, it often comes down to effective communication, whether somebody is able to receive information, evaluate information, and make decisions based on that information. Folks may be able to do that if they have their supports and accommodations to do that. And it may be, changing how you speak to the person, using plain language, slowing down, allowing, making sure a support person, such as a supporter under a supported decision-making agreement or some other party is there to help them make the decisions, or other adjustments. And I'm going to give you the next slide, recognizing that this probably violates a bunch of best practices around accommodations in terms of collar, contracts, and font size. The words don't matter as much. What I want to show you here is the range of accommodations, particularly around effective communication accommodations that are available. And the resource guide that Dina will send out. It provides, like I said, more information on working with people with disabilities, with more information on effective communication. The options are evolving. I feel like I learn about a new accommodation or support every week. And so, really seeing what somebody needs or making sure they have what they need to maximize their decision-making ability. Next slide, please. So in addition to evaluating somebody's capabilities and their decision-making abilities, we also want to evaluate their resources. Like I said, do they have access to the tools that they need to make decisions? Are there community service providers they are already working with? Friends and family and other folks who know the person, who maybe they just need some education about the role that they can play in helping that person make decisions if they can, and ensuring those folks are also afforded effective communication. Another resource I want to highlight is mediation. I think, we focus on mediation as a means to try and address conflicts, but I submit that mediators have these skills that can be applied in other areas, such as bringing people together to have a conversation and explore alternatives to guardianship. Mediation allows you to come up with more creative solutions than the courts are capable of. And this QR code will take you to a video on how mediation can be used to help explore alternatives to guardianship. So you've identified a person's needs. You've evaluated, their capabilities and resources. The next step in IDEAL is to assess alternatives to guardianship. We found that folks were kind of treating alternatives as kind of a checkbox, like, petitioner says there are no alternatives together and no available, but no questions are asked. So we needed to give folks a definition. We are also finding that folks were looking at alternatives as there's one alternative to rule them all, but somebody may have multiple needs and need a number of alternatives. So there are formal and informal options that alone or together allow a person to have their needs met without a guardian. And in the context of it requires an ongoing analysis. It's not this one snapshot in time. Alternatives should be assessed at all points, before a petition for guardianship is filed, after, and even after a guardian is appointed. Next slide, please. Alternatives can help dismiss or settle a case, before even before a trial. It can be used to limit a guardianship based on what's actually needed. There may be alternatives that can address 4 out of 5 concerns, but there's one area where court intervention is needed. And after a guardianship is in place, they are a means to terminate or modify a guardianship. And in the next slide, we offer an example of how, when you've identified those needs and we kind of came up with those categories, we offer here a way to organize or assess what alternatives may be available to address those identified needs. I know these are Maryland specific, but I am sure in your state there are similar parallel options and proceedings, some more formal than others. But it is helpful to give people a way to map out, what alternatives they might want to consider. And we include a resource guide with additional information about all of these options. In the handbook you'll receive. These options have always been available, but what we were finding is folks didn't know about them or were looking for that one option to rule them all. And in our petitions, we're kind of just seeing these check boxes. So one of the key findings is that everyone, including our judges, including our private attorneys, needed more information about the specific options. And after identifying a person's needs, evaluating their capabilities and resources, and assessing what alternatives to guardianship may be available, to the extent that there are needs that cannot be met, the last step and ideal, if you get there, is to limit any guardianship that is needed. It is a best practice. It allows the person to retain their rights, but to get support in the areas in which they do need help. For courts, we like limited guardianships. It allows you to have greater control and oversight over your guardians. Those limited orders don't allow them to get in trouble. Sometimes those limited orders can be helpful in resolving conflicts with other people in the case. And this would require a case-by-case determination. And guardianship, you can have anything from 0 to 100, and that can change. Somebody's needs can change over time. The alternatives can become more can become available or become less effective over time. Those powers of any guardian can be limited. It can be modified at any time. When limiting a guardianship, or advocating for a guardianship to be limited, or for courts to assess whether a guardianship can be needed, it's helpful for folks to have information, documentation, and the ideal tool can help create that documentation. Having information about what the person's needs and functional capabilities are, any challenges they're experiencing, any legwork done to screen for alternatives to guardianship or conservatorship, what alternatives have been tried and what have failed, and attempts to locate other people in the case, family members, friends, other folks. They can serve as alternatives, or they can serve as really useful sources of information to help determine, what is the best what is the best structure, if any, that is needed for an individual. So that is a quick and dirty overview of the ideal approach that we are launching with different audiences. Happy to talk to you more about some of the pipeline related issues. Here is my email address, and thank you all.
Thank you, Nisa. First of all, it's like you gave a masterclass in alternatives to guardianship and preventing plenary guardianship. So I appreciate that. And the fact that it's in an amazing tool form is just a perk. There are some people in the chat, including Judge Glenn. Thank you, Judge Glenn, pointing out that in New York State, part of our statute, 8116, talks about special guardianship, about how a guardian can be appointed for a specific reason, for a specific purpose, given powers just to get the thing done. And then once that thing is done, everyone is meant to go back to court. And as long as everything is good, that guardianship ends. It's not used that often. And so I think I'm really glad people brought it up in the chat and also privately, that it's something we all need to remember exists and can be requested. So thank you for bringing up all these types of limited guardianships as well. And the fact that guardianship is a spectrum, and that most people here from New York are lucky enough to live in a state where it can work as a spectrum. So now I'm going to bring on Diana. Thank you so much, Nisa. Diana is again, the director and special counsel of the Office of Guardianship Matters and Elder Justice. We are so excited that that office exists. She's had over 20 years of court experience engaging in system reform work and innovation to increase access to justice. And so she's developed expertise in so many different areas of law and administration throughout her career. She currently provides counsel, advice, and insight to judicial leadership and the Office of Court Administration. And the central focus area for her right now is the reform needs of statewide adult guardianship, system-wide. She also oversees and supports the newly expanded Guardianship Assistance Office, which many of you know as GAN. It's now the Guardianship Assistance Office, and provides programmatic oversight of nonprofit UCS grant recipients who offer guardianship services. She's also on so many different committees, so check out that bio. And I'm personally so happy that we have this position in New York State now and that Diana is in it, because I've had many wonderful conversations with her. So I'm going to turn it over to Diana.
Thank you so much, Dina, and thank you to the representatives from Maryland and from Massachusetts for sharing with us such amazing work that are taking place in your states. And you'll be hearing from me soon, because we really need to connect on some of these endeavors. So I'm going to talk today about a relatively new initiative that's taking place within the New York State courts, focusing on guardianship reform. So as an initiative of the judicial leadership of the New York State Unified Court System, centralized oversight of guardianships has been established to examine and address the reform needs of the Mental Hygiene Law, Article 81 guardianship system. Leadership and supervision of the initiative is provided by Deputy Chief Administrative Judge for Justice Initiatives, Edwina G. Richardson. Starting roughly 6 months ago, our first objective was to conduct a thorough assessment of the guardianship system to identify the areas that are in need of reform. As a part of this examination process, we had the benefit of speaking with several guardianship system stakeholders, including elder justice organizations, community nonprofits, legal services providers, agency guardians, adult protective services, retired and current guardianship judges, law clerks, and other court administrators in the trial courts and in the appellate divisions. A great number of these stakeholders have been working in guardianship for many years and care deeply about those who are subject to guardianship, their well-being, and their due process rights. One area of the system that was highlighted as in immediate need of reform is the lack of access to guardians for incapacitated individuals who are indigent. This lack of access results because the guardianship system is not publicly funded in New York. For those with means, appointed guardians and the fiduciaries that are necessary to ensure due process and adequate monitoring of the guardianships are paid directly from their estates. For the poor, however, guardianship judges have often had to rely upon pro bono, nonprofits with limited funding, and overburdened social services departments for guardians to appoint. To address this need for guardians, during the fall, we submitted a proposal to the governor for the creation of an office of the public guardian that the courts could appoint as guardian when no other individuals or entities were available, and to establish a separate governmental oversight office to ensure that guardians, court evaluators, court examiners, and others were performing the tasks required of them. While the governor did not announce the establishment of a public guardian office in her 2025 State of the State address, we remain hopeful that intergovernmental support and partnerships will lead to increased public funding for guardianships. In assessing court operations of the guardianship system, we learned that the infrastructure for processing guardianship cases varied significantly throughout the state. Within New York City, the Westchester area, and in Long Island, the courts have guardianship and compliance parts that support the judiciary in the oversight and monitoring of guardianships. The volume of petitions for guardianships is much higher in these areas, presumably due to the higher population density. In upstate New York, however, which is more geographically dispersed and has a lower number of guardianship petitions, there are no guardianship or compliance parts in the courts. While there was uniformity in the availability of court examiners to review reports throughout the state, though to a lesser degree upstate, we found that guardianship and compliance parts significantly bolstered the oversight capacity of the judiciary. Consequently, in addition to requesting an increase in staffing in the guardianship parts downstate, we are going to explore whether the creation of additional guardianship parts throughout the state is feasible and would assist the courts in monitoring guardianships. Being able to report accurate and comprehensive data on Article 81 guardianships remains a major challenge within the system. Court case management systems generally have been designed to help with processing the life cycle of a case, and not so much to assist with research needs. And this is especially true with guardianship cases. In the past, guardianship as a case type was managed in a similar fashion to all other case types. Thus, when a guardianship petition was either denied or granted, the case was marked as disposed as a final disposition. This made ongoing monitoring of active guardianships very challenging. Through the acquisition of an Elder Justice Innovation Grant in 2021, however, the Office for Justice Initiatives, in partnership with the Department of Technology and Court Research, successfully implemented an Article 81 module, where now, when a guardian is appointed, instead of being marked as disposed, the case is now marked as ongoing. With this innovation, the court system is now able to track active guardianship cases. 2024 marked the first full year of the implementation of this module. While this is a significant improvement in the court's ability to collect and report on guardianship data, ongoing review of guardianship technologies, data, and compliance revealed that there are at least 5 different technology platforms within the courts that collect guardianship data. And these systems currently do not fully communicate with each other, thereby hindering the court's capacity to comprehensively assess the status of guardianship cases. A technology project has commenced this year to provide consistency, visibility, and efficiency in guardianship case management. These changes will span applications, reports, and data managed by the Department of Technology, the local courts, and the appellate divisions. Application functionality changes and automation technology will be implemented throughout the year to better track appointments of fiduciaries and reporting compliance. With the support of the many practitioners within the Guardianship Advisory Committee and the judges and justices which comprise the Guardianship Roundtable, several legislative changes have been recommended to Mental Hygiene Law Article 81. One in particular is to help make public funding available for court evaluators and court examiners in low asset cases by having them listed as professionals who are eligible for compensation pursuant to Article 18B of the county law. At the end of next month, members of the Guardianship Committee will meet with state legislators to discuss the proposed legislative changes. Throughout the entire state, one of the greatest challenges that we learned about was the support needs for lay guardians in meeting their court-ordered and statutory obligations. In order to provide more support for lay guardians, staffing has been increased in the Guardian Assistance Office, formerly known as GAN, and the office is now supervised by the Office for Justice Initiatives. Guardian Assistance Office staff are also currently working on updating the mandatory lay guardian training and will assist the courts with identifying the unique resource needs of guardians who are older adults and guardians with limited English proficiency and literacy challenges. In partnership with the New York State Judicial Institute, we are also developing a guardianship judicial training and education track that will be implemented as part of the New York State Judicial 2025 summer seminars. The New York State Judicial Institute has also committed to the development of a fall series of educational curriculum on various guardianship topics for all judges and non-judicial staff. While time does not permit for a full briefing of the numerous items for reform that have been identified and that we are working on, we are very grateful for the many system stakeholders who have provided their time and shared their ideas to help improve the system in New York in order to achieve safe, effective, and equitable guardianships that are appropriately tailored and established only when necessary to secure the well-being of vulnerable and aging populations and to protect their due process rights. Thank you.
Thank you so much, Diana. Oh, I'm popping back on. I know that you're just working on so many different things. I don't know how you put that all into one little kernel there, but I also know that Diana is just, since she's gotten into this position, has spent so much time just talking to people and learning from people and understanding different issues from a lot of different perspectives. And again, that's why I feel really grateful that we have her working on this in our incredibly large state. So really, really appreciate you. We have to get some code business done, and then we have time for a couple of questions. So the final code is, get those writing utensils ready, 9YWX. That is 9YWX. One more time, 9YWX. Okay. And again, I am not administering the CLE codes. So make sure that you send the information to the email address, which will be on the forms that I'll send after this and also sent yesterday. So we have time for a couple of questions. For the presenters, if you could all pop your video on. One of the questions that we got is, this was addressed already. Okay, so this is to, I guess, to Heather and also to Nisa. You have created programming and tools, and you've clearly worked so hard on so many of them. Did you have to consider how were people going to find out about them? How do you get people to use them? Were you stressed about getting people to use them? I think there's such a pause to create new things because you want to make sure that they're actually used even when you know that they're good and they work. Can you speak to that?
Lisa, do you want to go first?
I was going to see if you wanted to go first.
I'm happy to. So I mentioned that we have been around since 2020. And when I first started, I remember so vividly getting on my little Zoom, ready for a presentation, and having nobody show up, and then just sitting there for 15 minutes and then leaving, and trying again next week. And now we're having 100 people show up, and we're having people just sign up and really excited and watch our videos and everything like that. So I think you just keep throwing spaghetti at the wall and see what hits. That wasn't the right phrase, but you just keep trying, because this is really exciting information and important information, and there are people who really appreciate it. But it's trying to find the right people, and so we, as a result, we have 8, 10, 15 people joining our Learning Hub every week. And so I think there's a lot of word of mouth. So it's just, once you get going and once you get an audience of people who trust you and know what you're doing and like what you're doing, they tell one friend, they tell 2 friends, and eventually you have people coming at you and asking for more. So I don't know. I know that it can be really frustrating to start out, but I just say keep going because it's really worth it.
And I agree with you, Heather. I mean, don't just because only one person shows up, talk to that one person and be patient and persistent and love talking about this with folks. And, you know, for us, and I'm with the court system, so there are a lot of limits to what I'm allowed to, you know, how I engage with folks. But guardianship is different. I mean, it's a court process, but it so relies on other people, and it's maintaining those relationships and having those conversations, because, you know, when it's often when something goes wrong that, you know, we're in defense mode, or we're in action mode, and you remember those conversations you had, building those relationships, getting people to care with you, and also engaging with us. I mean, the ideal tool came out of our discussions with so many different stakeholders, and also us being able to say, you all are fighting but against each other when you're all on the same page. You know, I think kind of, and hearing where people are coming on, what their concerns are, and pairing them with folks has been really effective in getting their buy-in by respecting them enough to hear from them and learn from them and incorporate what you learn has been effective. And again, I say this as the court system, having a judge in the room always helps. Everyone's going to show up to a meeting that a judge is at. Everyone's going to be in their best behavior. So if you have a judicial officer who knows these cases and love these cases, you know, they are the ones who can get people to come. And if you're within the court system, you might have an education division. You know, training the judges, we work through them, and working those relationships. Sometimes it starts for the folks who are on the ground, not necessarily the people who are the policymakers, to get that buy-in.
Thank you both. Another question that we got, hold on. Another question that we got, really, this is actually related to Nisa, to your tool again. Someone wants to know what's next. You have this tool. Is the grant over? Are you doing anything more with this?
Yeah, no, great question. And I'm going to give you one answer now. Check in with me in 6 months and I'll see if my answer has changed. You know, our grant ended last August. I don't know. I'm still kind of recovering from that. And you know, we kind of came up with it on the floor, actually, right here, quite late in the grant. So we've been testing it out with different audiences, particularly with judges and attorneys, and doing brown bag launches primarily with hospitals. So it's doing it on the local level. We're kind of getting some feedback still. We've really just reframed all our training programs around the ideal approach, and it's clicking with people. And I think the more people it clicks with, the more opportunities that will come up. Partnering with our protection and advocacy organization has been great because they're able to take this into the community. So they are getting requests to do trainings, and we will show up to the training that one person attends because that's the person we're talking to that day. But we have a lot more work to do. So again, it's changing the vocabulary, showing the results of our project. You know, there's this huge report, learning from that. So this is kind of going to be our new framework going forward, and then we'll make adjustments and refinements along the way. Like Heather said, sometimes you just got to throw the spaghetti to the wall and see how many, you know, pieces stick.
Thanks, Nisa. And then final question, Diana, I'm going to throw this to you. It's a question kind of related to the pool of guardians. We have now a lot of guardians are attorneys, like private guardians. What are the thoughts about trying to expand that pool to social workers, nurse practitioners, geriatric care managers?
Yeah, so there currently are social workers and care managers on the Part 36 list. And we definitely want to continue to expand that pool so that well, we're actually also going to improve our Part 36 training so that attorneys can learn more about the care disciplines and fields and not just the law in serving as guardians. So we're definitely working that angle, and we will be doing outreach to social work schools so that, you know, they can learn about guardianships, and we're going to do presentations and see if people are interested in applying and becoming a part of Part 36, which in New York is our professional guardians list.
Thanks, Diana. Yeah, Part 36 that she refers to is a list for professional fiduciaries, including guardians. So We have merely seconds left, so I just want to thank these wonderful panelists. I know that there were some outstanding questions. You can reach out to me. I'm putting my information in the chat again, trying to talk and type at the same time. D. Schwartz at projectguardianship.org. If there were questions related to particular guardianship cases, again, Project Guardianship does have a helpline for issues in guardianship in New York State. So I'm just going to put the website there. We do not offer legal representation or legal advice, but can help give you ideas and information and navigate situations. Also, if you're brainstorming alternatives, we're there for you in that vein as well. Really, really appreciate all of you for coming, all of you for participating. And I promise to send all the information out to everyone. And if you are seeking CLE credits, all the information will be in there as well. Thanks again, everyone. Bye.